New to our committee room. Okay, it's loud. That's fine. Well, we probably need to be a bit loud, although the water, air quality is very low.
Excuse me. We are live.
All right, good morning and welcome to the House Environment Committee. This morning, we are going to continue our discussion of S-124, hearing from the agencies involved. And we will start with Steve Collier from Agency of Agriculture. Welcome.
Good morning. Thank you so much and good to see you all. Steve Collier from the Agency of Agriculture. Thank you. Excuse me, sorry. Thank you so much for having both us and ANR in to talk about the proposed changes. We really appreciate that opportunity. If I can, I just want to level set a little bit because I think some of the discussion it's a very confusing subject. So I just want to kind of start from the ground floor. The state of Vermont, all of you and your predecessors have already gone far beyond what the Clean Water Act, the federal Clean Water Act requires. You basically, what you did was you created you created state law that's equivalent to federal law, and you made us in charge of it, the Agency of Agriculture. So the whole sort of bargain that the agencies have worked together to try to implement is to try to define exactly that line and to try to implement it appropriately for farms, is to make sure that all farms are meeting with the requirements of both federal law and state law. And the way that this was created over 20 years ago was that ANR would implement federal law and the Agency of Agriculture would implement state law. So the whole floor ceiling discussion, I think, is not really the right analysis. If you looked at it that way, then essentially ANR would be the floor and the Agency of Agriculture would be the ceiling. But I don't think that's the right analogy because it's a bit different than that. Essentially, what you did is there's a federal law room. Clean Water Act governs farms, but no one's in that room unless they're discharging. So just keep in mind that all of the water quality requirements that we have, both under federal law and state law, are to prevent farms from discharging. That's the whole basis. So this federal law room that's the Clean Water Act, nobody's in it unless they're discharging. ANR does not have jurisdiction over farms. They can inspect them, they can investigate them, they can evaluate them, but they don't require an actual CAFO permit unless there's a discharge. So basically there's the federal room, and then you built a new room, the state room, that's almost identical to the federal room. It's all the same requirements in the state room. The state room, every single farm in Vermont is in it. So every farm is covered. There's nobody. If you only had the federal room, there'd be a lot of people who wouldn't be covered at all. You didn't like that, or your predecessors didn't like that. So you said all farms need to be regulated. You built a new room. Now ANR is in this room too, because they can regulate farms, they can inspect them, and they can find out whether or not, if a farm in this room isn't doing what it's supposed to, they can pull them over to the federal room and take jurisdiction. So the wall that's between those rooms is a discharge. That is what separates the rooms. If you don't have a discharge, you're in the state room, federal law applies, but there's no jurisdiction unless you're discharging. So every single farm in the state of Vermont has to meet all of the requirements in the state room, which is almost identical to federal law. ANR's in there. They have been in there. We've been working with them. They've been operating. They have enforced the Clean Water Act. They haven't done everything that EPA wants them to do, but they have been cooperating with us. Farms, and importantly, farms are doing the work. Farms are meeting the expectations, not every time, not perfectly, but they have made tremendous strides. And we're working with them in the state room. ANR is in that state room. And the only question is, when do you get pulled over to the federal room? So this floor ceiling thing, you already built a whole new room. And I would suggest that if you don't think the requirements are enough in the state room, that's a substantive policy discussion. If you don't think that, we think they are, but if you think that something more needs to be done in state law, in the state room, that's a policy discussion about what else has to be done. But if you tear down, if you don't have the wall in between, everything gets blurred and it becomes really confusing for the agencies to figure out who goes where, and more importantly for the farms to understand where they want to be. Now, remember, the goal is no discharge. That's what we want. We do not want farms discharging. As long as they're not discharging, they live in the state room under all of the no discharge requirements. Once they discharge, ANR can pull them over to the federal room where they still aren't allowed to discharge. Keep that in mind. This is not about discharging. This is about not discharging. So you've got two identical rooms, and if you start taking that wall down, so A&R is reaching into the stateroom, it becomes really confusing. So the whole agreement was A&R will do federal law, which is what you set up years ago. Agency of Agriculture will do state law, which is what you set up years ago. And we will ensure that we're working together so that anybody that needs to be pulled into that federal room can be pulled into the federal room. So, I mean, remember the backdrop of this too, the whole reason that we're here is the advocates filed a petition and they want A&R to do all the work, which we understand that's what they want. But the agreement between the agencies and what S124 represents is, in our view, an acknowledgement that the work is getting done. It's not being done perfectly in the federal world or in any world. Regulatory work is never perfect, but incredible strides have been made. And we need to make sure that if someone has to be in the federal room, they're there. And then A&R regulates them. So that is the whole premise of this agreement that we've reached. EPA is on board with it. You know, the process is ongoing. They're going to continue looking at it. But to sort of pull more things into the state room it's not substantively effective. It doesn't do anything. Everybody's already in the state room. So if you think the ceiling is too low in the state room, maybe you have to raise it. But pulling A&R further into the state room does not change anything about how farms are regulated. They're regulated as you've told us to regulate them, which is through the RAPs and all the requirements in Title VI in the state room or under the Federal Clean Water Act in the federal room. So blurring those lines does not make it easier. It makes it harder to administer. And that's why we've come up with this agreement is we want to do it right. We don't want to debate who does what. And A&R, one thing to keep in mind is A&R has the absolute authority to decide who it regulates. I mean, it has to follow the law. It has to decide that a farm is regulated, but the Agency of Agriculture has no say in that. If A&R thinks a farm's over here in the state room is not doing something right, A&R can pull it over. And we don't decide that. We don't. And then once they're in the federal room, all the regulations apply. So from our perspective, it just makes sense to keep that jurisdictional split so that we can implement it appropriately. The other piece of this is an ongoing process. We're going to continue talking about this. There's a stakeholder process that's contemplated by this agreement, which is S124. And the purpose of that is to get farms and A&R and us all comfortable working together so that we can be, from my perspective at least, so we can be even more effective regulatory partners and so that farms are all doing what they're supposed to do, which is to not discharge. So in that process, there are going to be recommendations that come out. There are going to be suggestions about what should be done. And that, you know, all of these are legitimate policy questions, but taking the wall away does not do anything except create confusion. It does not increase regulations because you've already created a whole new room. In farms, every single farm has to comply.
I really appreciate your analogy. I think we get your analogy, but we have some specific proposals before us. I hope you'll get to those.
Sure. So I was trying to address, and correct me if I'm wrong, but my understanding was of the proposals that number 1 and 2 were the ones that the committee was focused on. So that's the one that would, would establish an inspection schedule and then create and take away the Clean Water Act as a regulatory floor. So everything I was just talking about is that issue about the floor. It's not a floor and ceiling. It's about who does what. And so we don't support it. The agencies don't because it undermines our very agreement, which was A&R does the Clean Water Act, Agency of Agriculture does state law. And this is a proposal to undermine that line, which doesn't increase regulation. It just creates confusion from our perspective. There's no increased regulation by saying A&R can step into the state room and do more. State law is what state law is. This is not a proposal to increase state law. This is a proposal to give A&R authority beyond the Clean Water Act, but our agency already does that regulation. So this is not increased regulation. This just makes takes away the wall. And so then it creates ambiguity and confusion. The inspection schedule, Catherine Gessing is here who will talk about A&R's perspective, and I think she's better to fully address that. But I would just say that the inspection schedule is not per se it doesn't exist under federal law. It's one thing you should all know. It's a state law That's a state law creation that already does exist in the state room. So this Agency of Agriculture is going to every large farm in the state every year to inspect it. ANR sometimes comes with us on those inspections. The plan going forward is that they will regularly come with us on those inspections, and they've submitted a corrective action plan to the EPA that talks about their inspection schedule that they'll be building out. So they're coming with us. So we're working together, and that's not going to be more personnel on each farm because we send two inspectors now, and we're going to have one from ANR and one from us. So every farm in the state, and this is longstanding, every large farm in the state is already inspected every year by the Agency of Agriculture, and ANR is going to be coming with us. So every medium farm in the state is already inspected by the Agency of Agriculture every 3 years. Every certified small farm in the state is already inspected by the Agency of Agriculture every 7 years. And we also go to every farm, as does ANR, if there's a complaint. So there already is an inspection schedule.
But we don't, you don't have to, you can finish your thought and then.
No, that's fine. Yeah.
Representative Bartholomew.
Just wondering how confident you are that if the Agency of Agriculture goes and finds a discharge, that everything is appropriately reported.
I'm very
Does it
confident.
happen every time?
Yeah, I believe it does. I mean, there has been in the past, and I think it's a pretty distant past at this point, there has been confusion about what should be referred and what should not be referred. My position on that has always been, we're the state of Vermont. If it, ANR gets to decide what the case is. If there's anything close, just give it to them. And if it's not a discharge, great. If it is a discharge, then they need to address it. But we're the state of Vermont. We should share everything we have that's relevant to what we're doing in our enforcement work. So I think a lot of time and energy was spent on trying to figure out exactly what should be referred. And there's value in that because we don't want to inundate ANR with things that are outside their jurisdiction. But my feeling, and I believe that we do this, and we've made 170 referrals over the last 5 years, I think. And that does not mean there are 170 discharges. It means there is something that ANR should look at. So I'm very confident in the work of people on the field, and that if they see something that they believe is a discharge or could be a discharge, that they're referring it to ANR. We also meet every week with ANR, with their CAFO program.
And the required agriculture practices include the water quality pieces. Right. And all farms, including small farms, are expected to follow the required agriculture. Is that true?
Correct.
Right.
There are some jurisdictional limitations. So there are some really small agricultural enterprises that are we call them sub-jurisdictional. They're under the RAPs, but the RAPs, they're all encompassing, because if you are selling even $2,000 of agricultural crops every year, you're covered by the RAP. So there's no commercial farm that's not covered by the RAPs. There are some homesteaders that sort of are close.
Representative Logan.
I guess I'm a bit confused about why there would be an objection to aligning the ANR's inspection schedule with the Agency of Agriculture's inspection schedule, if we expect ANR to accompany the agency.
It's John fiddling.
That's a great question, and I think it's Let me turn that.
No, we're gonna let it be. And if we deal with it at a break, if we need, to, we could just stay focused on the conversation. That would be really helpful.
I think it's resources is the critical reason. We're already out there all the time. ANR is coming with us. You know, we have in our agency, we have about, I think it's about equivalent of about 9 employees who do inspection work total. And there are hundreds of farms in Vermont, many of them very small. Under this proposal, ANR would be going to a lot of small farms that it almost certainly never will have jurisdiction over. So you're requiring them to go look at farms that we're already on, that there's almost no chance they're going to need to have a CAFO permit on. So if they had all the people in the world they needed and the program was set and running and going strongly, maybe an inspection schedule is important to do, but that's the whole point is right now, and there's never been a CAFO permit in the state of Vermont. And what we're trying to do is ensure that anyone who needs a CAFO permit has it. So it makes sense when you have limited resources, we think, to target those resources to the most vulnerable farms. And ANR is working on a list. They're working with us and what farm and with the EPA about what farms they want to prioritize. They've got they've got a compliance schedule in place. They're going to have to come up with their own internal mechanisms to deal with this. It's just when you're trying to build and get in place to require them to go some places where they're almost certainly not going to do anything except go look and come home and spend time writing a report about it is maybe not the best use of resources. In a couple of years, in a year, if we, 3 years, whatever it may be, when we know whether we're going to have one CAFO permit in the state, no CAFO permits in the state, or 30 CAFO permits in the state, there's going to have to be an assessment of resources and where they should be. But right now, the Agency of Agriculture, and has been, regulates every single farm. ANR has been working on that too. But as they build out their jurisdiction and figure out, again, remember, we don't want discharges. We want farms to not discharge. So it's not a victory to get CAFO permits. It's a victory to have farms not be discharging. But we also have to follow the law. So if they are discharging, ANR certainly needs to step in. So I would just say it's premature to develop an inspection schedule for, I think it's designed for 2028. Why? Like, why do that today when we're having this ongoing discussion about what should happen? And before we know how many CAFO permits there are, like in 2027, if you believe an inspection schedule needs to start in 2028, put it in. But I think we'll have a lot more evidence then.
Just to follow up on this topic, I thought I heard you say that ANR was going out with ag and would be on this schedule essentially. So I don't know what's wrong with us making our expectation clear in statute.
Well, they're going to be prioritizing farms where they think there may be a discharge. So we've been making referrals along the way. EPA did some of its own inspections when it was doing its investigation after the dedelegation petition was filed. So ANR is working to identify the farms that it thinks are highest risk and then it wants to visit. And the plan is for it, keep in mind, it has 2 employees now. There's a third that's coming from reclassification, and there are 2 in the proposed budget. But I believe that they will prioritize large farms first, because under federal law, a large farm actually is a CAFO. Doesn't mean it needs a permit, but it is a CAFO. And so they have a more obvious, like, ongoing role on large farms that are CAFOs to check their nutrient management plans, to make sure the farms are complying with them. So I think, and I'll let Catherine speak more to this, but I think the plan is to inspect the farms that are most worthy of it first. And if you start putting them on a 20 cow farm, that even if they found a discharge, they could never find it was a significant.
So I guess I heard you say ANR and AIFM were already going to farms together today.
We do,
So
but not on the same schedule. They don't go, we go to many more farms than they do. They select which ones they want to go to.
and then under this proposal, I guess I'm seeing it says each small farm operation, not less frequently than once every 5 years. I'm assuming it means an animal feeding small farm, like not every small farm has animal feed operations.
Sure, but that's still hundreds. I mean, we have 439 dairy farms. We have, I'm not sure how many other farms that are AFOs, but there are other AFOs as well. So most of those are.
Questioning whether ANR has the resources to do this.
I'm questioning 2 things, whether or not they have the resources, and also whether it would be an appropriate use of the limited resources they have to put them on farms where they almost certainly will not have jurisdiction. If there's a complaint, if we go there and we find something, they're already going to get notified. So instead, you're telling them potentially to go to 300 farms where they would not only have to find a discharge, but they would also have to find that that farm is a significant contributor in order to get a CAFO permit. And we're already going there. So it's just, if they had employees who didn't know what to do with themselves, it maybe would make sense, but I don't think that's where they are.
Okay, thank you. We need to move on. We've been here for 20 minutes. We have other witnesses to hear from. Did you have Representative Chapin?
Very quickly, I think
Okay.
it sounded like already the plan is for ANR to come out on large farm visits. So you'll have one person from Agency of Ag and one from ANR. Do you expect that to start sometime this summer?
Yes. I mean, I think the plan to the EPA was ANR would do 10 inspections this summer. So that's not every large farm this summer, but they can come to anyone they want, and that's always been true. But
Okay, thanks.
How many staff do you have doing inspections?
I think it's about 9 equivalent when you talk about actual inspection work. That's there's some half-time and some do other duties, but it's about 9.
Right. Any last questions? Representative Labor.
Thank you, Chair. out of the 170 referrals done over the last 5 years, how many farms actually ended up having discharges?
I don't have that information because that's, once we send it to ANR, we hear back from them, but it's not it's in there. I don't know. I'm just not sure.
Representative Bartholomew.
I'm just wondering what you thought, maybe you said and I didn't catch it, but the proposal to make this at least as stringent as the Federal Clean Water Act, that I think is coming out of concern of what Washington might do. Is that a good idea?
Well, that's a great question. And there is a separate bill that I think you heard about that might memorialize the Clean Water Act regulations as, I think it's H 319, I think. But that might memorialize the Clean Water Act regulations as they were in effect on January 1st, 2025, I think. But I think the easy answer to that question is, even if federal law went away, there'd still be the state room and we would still be doing our work in the state room. And everyone's worried about what may happen when federal law changes. I think it's really, from my personal perspective, is it's really hard to deftly navigate those changes without knowing what they are. Because federal law may get worse, it may get better, but more importantly, it may create conflicts. It may create issues that you might not be able to reasonably implement regulations that existed before and now if they conflict with one another. So I support the initiative. I'm not sure how it will work if federal law changes. Our thinking is if federal law changes, we've got to assess it and figure out how to deal with it to make sure that we're still doing our job. But all of the state regulations that are in play will continue to be in play, regardless of what, if anything, the federal government does.
Thank you. We really need to have an
Okay.
on team. I mean, I know this is important, but Representative Austin.
Yeah, I feel like this is an issue of implementation, oversight and accountability. I feel like it has been going on for a long time. I'm in Colchester and Mallett's Bay. We're now compromised because of ag discharges. You have St. Albans Bay, Missisquoi Bay that can't even be used in the summer. So I'm wondering how again, this has been going on for a long time. This is not a new issue. How will you be accountable to this committee? How will you report back in a year or next session and talk about what you've done and what changes have occurred because of your actions?
Well, we're always accountable to the legislature, and we regularly report both to this committee and to the Agriculture Committee. And since under the TMDL, agriculture, despite only having 25% of the investments, is responsible for at least 80 and usually over 90% of the phosphorus reductions every year. Agriculture pollutes, but so don't all the rest of us.
Mhm.
And so farms are doing that part, and we do need to eat. And so if we get rid of all the farms that are here, that doesn't mean there's any less pollution. There might be less pollution in Vermont, but there's also the transportation cost of bringing food here, and we're just displacing our burden on someone else. So I don't think it's a question of whether or not we need food. The question is, how do we regulate farming reasonably so that we can have both food and clean water? And that's an ongoing issue. We're not doing it perfectly, but farms have made incredible strides, and it's driving them out of business. I mean, not just the increased costs, not specifically this, but you have to be able to compete. And we have much more stringent regulations than exist in a lot of other places. And so those regulations are great for the environment, but they also cost money. So finding that balance, and the legacy, I'm not an expert on legacy phosphorus, but there's a lot of phosphorus that's in that lake that's affecting it now. And we are definitely diminishing it. But when we drive here to work, we're causing pollution.
So would just safe to assume that the majority of farmers, I believe, are doing the best they can to not discharge. I feel like, and that is it accurate to say that it's a small group of farms that are not complying with the regulations?
I think it is. I mean, farmers there was a lot of resistance at first because it's expensive and it costs them money, and they don't personally benefit from it. They benefit as citizens of the state. but they have really embraced it. I mean, they've formed 3 different watershed alliance groups that work on it. They want to do their part. They don't like being vilified. They care about the environment too. I mean, people who are on the land tend to care about their land a lot. They want healthy soils. They don't want to discharge. So yeah, they've bought in. There are resource deficits. There, you have a floods like we've had. Those cause enormous problems. So there are some farmers that are more difficult to work with others, but we have the authority and ANR has the authority. Sometimes that's a messy process. It can take too long, but sorry, I think.
Yeah.
Thank you
for
so
your
much.
testimony.
Appreciate it.
Well, thanks.
The only, if you're considering the 5th proposal at all about CAFO regulation, and I didn't think you were, it's wrong. And I'd like to talk about it because it misunderstands the difference between large CAFOs under federal law. It would create problems if you adopted it, but I'm assuming right now that you're not interested in that one, and I'll cede the floor. Thank you.
We heard that. That's going to be considered in the study. Is that correct? Yeah.
Thank you very much.
Thank you.
Yes. Catherine Guessing.
Good morning. I'm Catherine Guessing, General Counsel for the Agency of Natural Resources. Instead of talking at you, I guess what I'd like to know is what would be most helpful to you. I can talk a little bit about the inspections right now. Just for background, right now, ANR only has 2 CAFO folks in their program. As part of our corrective action plan with EPA, which I think you're all aware that we're subject to a dedelegation petition, we have a corrective action plan. It's essentially a 4-year plan that we're working with EPA to kind of get ourselves up to speed on regulating CAFOs under the Federal Clean Water Act. So part of that plan is that we've requested 2 additional positions, and we're also, which would have been granted up to us, we're going to have to go through the process of getting, the position numbers and filling those positions. And then we're also going to transfer a vacant position from another place into the CAFO program. So to give us some more ability to implement the program going forward.
So does that mean you'll have 5 people working on
We'll
it?
have 5 people initially. And part of the corrective action plan requires us to come back to EPA and make recommendations about whether or not we need more resources and more staff. Right now, we're sort of in the position where we don't quite know what we don't know, right? So we need to have people getting out on the farms. We need to implement permitting templates. We need to go through the stakeholder process and get input from farmers. So we're sort of staging, gearing up to implement the corrective action plan that we've submitted to EPA. So, and the reason why I bring that up first is because it is relevant to the inspection schedule. I think that, Ag has a very similar schedule in their regulations. And I don't know that we would, be opposed to having an inspection schedule, but I do think it is premature at this point because we don't exactly know how many permits we're going to be issuing. We know that there are some farms out there that are discharging. There is a difference between a discharge that can be corrected immediately and one which requires infrastructure. And so there are, several farms that are moving through kind of enforcement processes, a handful of farms that may be required to get CAFO permits as part of that process. That's a process where we've been working with both Ag and the Attorney General's office. So I don't have exact numbers just because those processes kind of need to play out. But there are a handful that I think will end up getting a CAFO permit sometime within the next year. So,
So can you tell us what is your plan for inspections going forward as we're gearing this program up?
yeah. So, one of the things that EPA asked us to do was to commit to 10 inspections this year. And I think that number is low because because we only have those two staff and it's going to take us a while to get those other folks on board. There's a couple of different things. Ag has a really good database about farms and their inspections. And we are working with IT and with Ag to share that database and also make some changes to it so that it includes some fields that are particularly relevant to federal CAFO. And that database will give us information about what farms have had past issues, for example. We're also getting input from Ag and we're getting input from EPA about those farms that they think should be a priority, at least initially in this year and next year. And we're developing criteria sort of based on the database, but also based on the site-specific characteristics of where the farm is located, what its proximity is to waters, and what types of soils there might be on the farm. So, those are all sort of criteria that we can look at to establish at least priorities so that we're looking at we would be inspecting those farms for which we get complaints. So we get citizen complaints about all sorts of things, right? We get them about, burning. We get them about farms. We get them about trash dumping, all of that kind of stuff. So we have sort of a set of criteria that we're looking at to prioritize the initial farm inspections. And then at some point, I think we will develop a more sort of routine schedule based on what we find in the field, based on feedback from EPA in the corrective action plan.
And how long have you had these two staff for CAFO?
We just recently got the second one. So we had two initially. One person left and it took a while to maybe 8 months or so to refill that position.
But when did
So I think the last 3 years or so.
okay. And so they've been going out on farm inspections?
They have, and they both have farm experience, which is really critical to this kind of work. In terms of, assessing nutrient management plans, really being able to work with farmers to look at whether these are appropriate, that kind of thing. It's definitely an area of expertise, which is in large part, why we've been working with Ag to try to stand this program up.
Further questions on this? We're sort of covering, I think, the schedule and first, and then we'll get to.
Mhm.
Yeah.
Can you prioritize clean water?
I think we do.
You do, okay, because you were saying you go to other things, and I'm just wondering if clean water can.
The reality is that in Vermont, I shouldn't say most, but a large number of farms are in, the Lake Champlain watershed, right?
Yep.
Some are in the Connecticut River watershed. So, yes.
Okay, thank you.
So I'm hearing you say that, do you have the staff to meet the schedule that's proposed in recommendation 1 here?
Not now. And, at this point, what we don't know is how many permits we will be issued. Because that's going to be something that we learn as we go through the process of implementing the corrective action plan and getting more staff on board.
And I understand that you're kind of needing to, create a program here, but also I would like assurances that A&R has a plan to get to all of the farms. They need to know what's happening on all of them with their own eyes,
Yeah.
and inspections.
And I think that is the firm directive of EPA. So it's not only, I think, in the interest of this committee and others in the legislature, it's in our interest, and EPA is watching. I mean, they are still looking at the second version of our corrective action.
So what assurances do we have in this bill that that's going to happen?
I think part of what's useful about this bill is that it sets forth the definitions for CAFOs, that it provides sort of clear authority for A&R to go onto farms, that it provides clarity around what our authority is with respect to CAFOs. In terms of accountability, we do have a CAFO report that we submit to the committees of jurisdiction. I will check and make sure that it comes to environment.
We would be.
Things have kind of changed.
For water.
Right. But the committees seem to have changed a little bit. Ag and forestry, well, no, so it would have been to you,
Yeah.
right? Okay, so it should go to Senate and House Environment. And then I think we've said all along that we intend to come back next session after we've gone through the stakeholder process to, if we need additional sort of tweaks, if this is not really the end of this conversation, because we really are just beginning this process of implementing the corrective action plan.
Do you have a sense of how many staff you would need to visit every farm?
Yeah.
No, I'm getting.
No.
Yeah.
Honestly, no.
That's good.
To the extent that ag visits every farm, I think it would be somewhere around that. No, but it may be less, it may be, I think we'll have more information about that as we walk through the corrective action plan and start getting boots, more frequent boots on the ground on farms. So.
And now to recommendation 2, the regulatory floor recommendation. Can you speak to that?
Yeah, I mean, I don't really have anything to say that's different than what Steve Collier has said. Federal law, including the Clean Water Act, allows states to be more stringent. There are places where Vermont has implemented more stringent, regulations. At this point, we are really focused on trying to satisfy the delegation to stand up the program. And we were not looking for additional authority. So, yeah. I mean, I'm happy to take specific questions about it, but.
Members have questions. Representative Sakowitz.
Yeah, so I guess I'm just really wondering if the rules or the Clean Water Act itself were to change and become, less protective of our waters, how would that affect your work in A&R?
So,
The response of the agency.
I think Council O'Grady spoke to this yesterday. Two things. One is that there are some definitions in the current version of S-124 that would be helpful. In other words, if the feds were to lower the definition or change the definition of CAFOs, we have in our statute a definition of CAFOs, right? And so that's very helpful. The other thing is that to the extent that we are relying on federal regulations, there is legislation, I think it's in S 319.
It's H 319. It's also.
Okay.
For all agencies in 397, I think it is.
That sort of preserves those regulations in time. It doesn't mean that we can't go in and change them at some point, but at least gives us some assurance that you know, our statutory provisions, our regulations are not going to be changed.
So given what you just said, if we pass this and it says that the secretary will implement the Federal Clean Water Act to administer Vermont pollutant discharge, KEPD's CAFO program that is consistent with and equivalent to the Federal Clean Water Act, and the feds change the definition of CAFO. Wouldn't we be subject, wouldn't you, your agency be subject to a suit?
No, because the Federal Clean Water Act allows states to be more stringent. And our S-124 actually has the definitions of CAFOs in it. And so if the federal EPA were to change the definition of CAFO so that it was, I don't know, or even eliminate it,
I just struggle.
we would have it in our statute.
Okay, that's helpful.
Yeah.
I want to trust that system, but the words are equivalent to the Federal Clean Water Act is very specific.
Yeah.
Which that makes me really uncomfortable. So I think, we're not, we're trying to find a solution here that gives us some security.
Some assurance that it's not going
Maybe
to.
this isn't quite the right language, but
Right.
we'd really love your help.
Representative, do you have something more to say?
I'm just thinking.
Yes.
So I'm happy to, let me think about that.
Representative Logan.
Yeah, so I'll ask the question, I guess, a little bit more directly. Would the agency object to the language saying that the program should be at least as stringent as the Federal Clean Water Act in order to give the agency flexibility to define rules?
It's not something that we would support at this point. In the sense that I don't necessarily think it's not consistent with sort of how we've sort of designed the corrective action plan. We don't necessarily think it's necessary at this point, but.
Representative Tagliavia, then Bartholomew.
The wording in S-24 that came out of the Senate, it doesn't include this. Doesn't that give you the latitude to make changes if need be? So we don't need to be worrying about this, at least as stringent. I think you just said that the EPA rules allow Vermont's regulations to be more stringent already.
They do. What I understood the question to be is, does the at least as stringent as the Clean Water Act sort of limit us if the feds were to change the Clean Water Act? And S-124 doesn't necessarily include all regulations. I mean, we've got rulemaking authority that we're going to, implement. We're going to go through that process of, so I mean, I guess it could be at least as stringent as, the date. I don't know.
Do we know when these supposed changes may come down? Is it by October? Is that? Or is it any day, or we're only 6 months away from another session where we can sit here and debate whether we need more stringent regulations, correct?
We don't at this point. I mean, we're getting, reality is that EPA has lost staff. We're getting directives from them about grants, things are just changing really quickly. And I don't,
My concern is we're wringing our hands over nothing.
I see.
There's a lot of people who don't agree that it's nothing, but Representative Logan.
Yeah, my concern is that we're
Sorry.
creating a very explicit equivalency between Vermont law and federal law when we have a lot of uncertainty around federal law, and loosening the language gives the agency the ability to make the decisions that are best for Vermont without having to come back to the legislature for authorization. It doesn't mean that the agency has to do anything different than the Federal Clean Water Act. It just means that they can't.
Representative Bartholomew.
We heard that the Agency of Agriculture has a schedule to inspect essentially all farms. And I'm just wondering how confident the personnel at ANR feel that if agriculture finds a discharge, that it's appropriately reported.
I think at this point, we're very confident that that's happening. And I think the fact that we will have a shared database will be, just another sort of check on that, where we can go in and look at the database and look at the inspection reports ourselves. And as we sort of gear up and get out on more and more farms, we'll have a pretty good sense of, what we're going to find. We'll have a better sense, let's say, of what we're going to find out there.
Thanks.
Representative Sakowicz.
I have a couple of thoughts. One is we've heard about how Vermont has the authority to create rules which are more stringent than the federal rules. But if we say in the bill that our rules need to be equivalent to, then we're giving up that ability to do so unless we change the law in this particular case. And so that's a concern of mine. The other thought I have is that I think I heard that there's some objection to making it at least as stringent because we are considering language in other bills which would have the equivalent effect. But if that's the case, then I'm not sure what the harm is of doing it here, since this doesn't require, as was noted, the agency to actually do anything. Just gives them flexibility, and those other bills are not law. We actually don't know for sure what's going to happen with those. So it seems like our prudent choice here would be indeed to change this language to give the agency this authority. And I haven't heard, I don't think, a reason why this additional authority, which, if things go well in the world, we would never use, why it's a problem.
Can you speak to that, Ms. Gessing?
I mean, A&R does have other programs where we are being more stringent, right? We have to go through a rulemaking process to do that. In this case, we are, we've submitted a corrective action plan that has certain specific commitments in it. We're trying to work with agriculture the Agency of Agriculture to make sure that we're running as efficient a process as we can, that we utilize their expertise to the greatest extent that we can while we gear up. And I think that we we're reluctant to sort of change course in the middle of this process. So we, like I said, we just, I can't say that we would support this. That's all.
There's no particular problem that this change in language in this
I think
cause.
it depends. The specific problem may be that folks are concerned about certainty in the regulatory scheme. I mean, right now we've got an agricultural program that is very well understood. And we have a CAFO program that is in the process of being implemented that people really don't know anything about. Farmers are understandably have concern about the uncertainty of what that might entail. And this, the language as written provides some certainty to folks. So.
Representative Tagliavia.
The question about agencies, interagency notifications, is the database that will be shared set up so that notifications can be made automatically, so there will be less worry or concern about, oh, well, we forgot to mention this one or that one, so that it's more automatic and would be in notifications in a more timely manner.
We're really just starting those conversations with IT. And I think that is one of the criteria that we're interested in. It's been a two agency conversation. It's a really sort of comprehensive database that Ag has set up. It's pretty interactive. I haven't used it myself, but our staff are pretty enthusiastic about having access to it. And hopefully we'll be able to kind of get that implemented in the next 6 months or so, because we've already started meeting with IT.
So can I take that as
Yes,
interagency notification
yeah.
is on your radar?
Yeah, it is on our.
Thank you.
Representative Labor.
Thank you. In previous testimony, it was 170 referrals in the last 5 years. That got to your department. Out of the 107, how many were proven to have discharges?
I don't actually know the answer to that. I think that I will say that out of that 170, there's probably only a handful that are going to be required to get CAFO permits. And that may not necessarily mean that there wasn't a discharge, but some discharges are temporary in nature, can be fixed quickly in the field, don't require infrastructure, don't require sort of ongoing work to address. So, but I can, I think we probably could do a better job tracking that.
Right, any further questions? Representative North.
Yes, thank you, Chair. Just one question. What reviews and approvals, if any, has the EPA already provided of the ANR's response to the EPA's request resulting from the delegation?
So we submitted a draft corrective action plan. Hoping I get the dates right. I think sometime in December, and we heard back from them in March saying essentially, you're headed in the right direction, but we want more detail. We want you to fill out more detail, for example, in regarding the criteria that you're going to use for inspections. We want you to give us a date certain for when you're going to do rulemaking. We'd rather not, we don't want it to be in this year. We'd like a date certain. We'd like a little more detail around how you're going to structure kind of the document that explains the division of labor, if you will, between ag and A&R. Personally, I've had some discussions with EPA staff, which have been encouraging in the sense that they're, supportive of the second submission that we made, but we haven't gotten a formal response from that yet. And that may in part be because of the sort of staffing issues, and they're sort of changing their whole process of management approval. So
Do I understand from from your response there, then that a second submittal was made that did answer all the questions that they were looking for?
Yeah.
To further details.
it did.
When was
But
it?
we haven't gotten a formal response from that. It was, we did that March 19th. So,
How much time do they have to respond?
they don't have a deadline.
No.
Sorry.
One last question,
Yeah.
Representative.
So we're up to me tomorrow. No.
Just kind of being a new member to this committee, just if the EPA disappeared tomorrow, would Vermont with the A&R and ag still be held to very high standards to the statutes for clean water?
We have in chapter 47 and also in title 6, pretty stringent standards. Those will not go away. So
Is that
those would still be there.
can you say if that's the floor or the ceiling?
It's in the room.
Well, I would say that the concept of no discharge is definitely more stringent than the Federal Clean Water Act. Having said that, we do know that there are some farms out there that are discharging and they should have a permit. And so that's our job to kind of make happen within the next, the time period that we have to implement the corrective action. So, yeah.
Thanks for your testimony.
Thank you.
I do want to give the Conservation Law Foundation a moment, since they are a large part of why we are in this conversation to begin with. If you're willing, Elena Mahaly, with short notice.
For the record, good morning. My name is Elena Mahaly. I'm the Vice President of Conservation Law Foundation's Vermont office. I am the person that waded through thousands of public records, the documents we got from the Agency of Ag, the inspection reports that showed the problem, that showed that 75% of the time, the nutrient management plans on farms were not complete. They were not being followed. They sometimes weren't on the farm. Sometimes there were 200 to 400% more manure being spread on farm fields than was permitted by the nutrient management plan. And it was acknowledged and not ever dealt with, time and time again. So that was 3 years ago that I was wading through those documents. Since then, I've graduated from being a senior attorney working on the project to being lead of our office. And I've had the pleasure of working with Scott Sanderson, who's led the charge on our petition work. But I feel strongly that this is not a choice that we have to think about whether one policy decision is better than another. This is a federal Clean Water Act law that the EPA has found the state is not in compliance with. And they were very clear in their communications to the state that it is the Agency of Natural Resources that needs to have eyes, ears, feet on the ground on these farms. So with regard to the inspection schedule, I hear that they don't have the staff today. And I also hear that they don't know exactly how many staff, but I think we can wager a guess that given that the Agency of Agriculture is doing it with 9 to 11 people, that's a reasonable figure. And the year that we're talking about is 2028. It is several years out into the future. And as Chair Sheldon was saying, this is about accountability. We've gone too long trusting that this system is working and it is not. And so having in statute a date by which they are obligated to have this system in place is consistent with what EPA is asking that they do. It's just setting a time of when they have to do it by, because just believing that they will follow an unenforceable corrective action plan, that's not enough. So that's why we're asking for it to be in statute. As regards to the floor and ceiling conversation, I think Representative Logan said it well. This is not asking the state to make anything stronger. It is actually just providing a preventative mechanism in place so that if federal law drops, Vermont still can maintain its ability to be at least as stringent or go above the Clean Water Act. And I'm sorry, by the like farmers want consistency, this body can change the law year after year. This is a world where, you know, there's always going to be a subject to change. And I think this is almost a statement and a line in the sand that this body is saying we are continuing to have a state and that it can go beyond the Clean Water Act. It's an important signal right now, given everything that's going on federally. And I haven't heard, I think, you know, you have to remember who you're asking and what folks can and cannot say in this moment about what they object to or what they support. And I have not heard in this room a good reason to not do that floor amendment today. So I'm happy to answer any questions, but I want to keep it short.
Members have questions? Thank you.
You're welcome.
All right, let's take a 7-minute break and come back at 10 minutes.